Yeah, you know what time it is. Disclaimer, I am not an attorney, nor do I offer or give legal advice. So please understand that all information that we talk about in any of my webinars are strictly information and educational purposes. And most of it is just personal experiences with things anyway. So please understand this is not legal advice. And may you be blessed on your journey to find your power within these laws. Peace and blessings. Greetings. We have pulled up here deed of trust. As you can see, now I want you to pay attention to this document very closely. This is pretty much standard documentation that's recorded upon the county records, and they do this so much so that the average person just doesn't know any better, okay? And they just don't know exactly what this stuff means. Now we have the deed, which always pertains to real property, and now we're talking about a trust, which is a three-party contractual agreement. All right. Now, in that three-party contractual agreement, we have the trustor / grantor of the trust. Then we have the trustee. Then we have the beneficiaries. I always like to point out this relationship is like a situation between parents, babysitter, and children. The parents are the grantor / trustors. The babysitter is the trustee, and the children are the beneficiaries. With that situation, we understand that the beneficiaries, which are the children, are not going to tell the babysitter what to do. We also understand that the parents have put faith and trust in this babysitter on behalf of watching and attending to the beneficiaries, which are the children. Okay, so with that understanding, let's look at this document. We have, first, we're looking into these definitions. They have the security instrument saying that that's what this document is. We have borrower, which is an unmarried woman and an unmarried man. Now, this document has been edited to protect the privacy of these individuals, but the point we're trying to make is all we need to see. Borrower is the grantor under this security instrument. That's the key word we were looking for, right? Grantor. Notice how they wrote the word lowercase font versus the word borrower. Borrower is making somebody think that there was a loan that took place, right? Versus the word grantor make you think somebody has power to grant something onto somebody else. Now we have lender, who is a Mary First Financial. Lender is a corporation organized and existing under the laws of Arizona. Notice this big old space here. These documents be templates and they just copy paste their words into here. Lender's address is here. Lender includes any holder of the note who is entitled to receive payments under the note. D, trustee. Okay, this is the second person we identify. This is the babysitter. We've identified the parents as being an unmarried man and unmarried woman, right? They are the grantor / trustor in this document. And then now we have the trustee. So the third party we are looking for is the beneficiary. As we scroll down, we have another definition, MERS. MERS is Mortgage Electronic Registration System, INC. MERS is a separate corporation that is acting solely as a nominee for the lender and the lender's successor and assigns. MERS is the beneficiary. Okay, so that's the third party. MERS is the beneficiary. So MERS is the what? Children under this security instrument. MERS is organized and existed under the laws of Delaware. Do we know what's so special about Delaware? A lot of corporations like to register under these laws for what's called anonymity, and has an address and telephone number at P.O. Box 2026, Flint, Michigan. Okay, there's the number to MERS. Now we've identified the three parties. Now we're not going to go into all of this note, loan, and all that good stuff because we've already went over that in the video. What I'm trying to show you is something that I uncovered while I was involved in a real estate transaction with these people. So let's scroll down to see who actually signed the document, because we figured out who the parties that was involved, right? So we know and understand under simple contract law there has to be what's called meeting of the minds. So now we get here to the signature page, and information has been redacted to protect the information of the people, but you see that there was two signatures here which were from the grantors. What you do not see is no initials or signatures from the trustee or the beneficiary or anybody acting on their behalf to satisfy the element of the meeting of the minds in this contract offer. Okay? Now, did you see this? Now let's look at something else. Because in this situation, we've identified the three parties, right? We've identified who the grantor was, we identified who the trustee is, and we identified who the beneficiary is. Now, under standard trust law, the trustee is a fiduciary, okay? The fiduciary is being given power to do something on behalf of the beneficiaries. All right, the power is given to the trustee by the grantor / trustor. All right, now, I'm gonna scroll a little fast as we get to the top of this thing. We're gonna go to this next document. So, as I was doing research on this property that I was in a real estate investment opportunity with, I came across this document that was recorded on the county records, and I wanted to see if everything lined up. Now what we have here is a corporate assignment of deed of trust. The contact person is JP Morgan Chase Bank for this instrument, with this address, a lot of loan number and all that good stuff. It says right here, for good and valuable consideration. Y'all catch that? Valuable consideration. The sufficiency of which is hereby acknowledged, the undersigned, Mortgage Electronic Registration Systems, Incorporated, MERS, as beneficiary, as nominee for AmeriFirst Financial, Incorporated, its successors and assigner. MERS, here's their address, by these presents does convey, grant, assign, transfer, and set over the described deed of trust, all liens and any rights due or to become due thereon, to JP Morgan Chase Bank, National Association, whose address is here, its successors and assignee. Okay, so we identified MERS as the assigner and JP Morgan Chase Bank as the assignee. Said deed of trust bearing the date 11/30/2021 was executed by grantors. Now, this information has been redacted to protect the identification of the people. To Mortgage Electronic Registration Systems, INC, as beneficiary, as nominee for AmeriFirst Financial Incorporated, its successors and assigns, and recorded as this instrument number at this document in this county. And witness whereof, this assignment is executed on this date, which is August 17th, 2022. Mortgage Electronic Registration System Incorporated, MERS, is beneficiary as nominee for AmeriFirst Financial Incorporated, its successor and assigns. So who signed this? Someone by the name of Mary C. Whitfield, Assistant Secretary, on behalf of MERS, the assignor. So she's signing on behalf of MERS. MERS is the beneficiary. Do you catch the problem with that? Well, let's keep reading. This document was notarized by Eva Reese. Okay, she said Mary C. Whitfield, to her personally known. Eva says she personally knows her. Who did say that he or she, they is, or the Assistant Secretary of Mortgage Electronic Registration System Incorporated. They did say, that's all. She knows it, but she didn't say no type of identification, no type of authentication was presented to her to identify herself as working for MERS. as nominee for Mary First Financial Incorporated, its successors and assigns, and that the instrument was signed on behalf of the corporation or association by authority from its boards of directors, and that he, she, they acknowledge the instrument to be the free act and deed of the corporation or association. Ooh, that's a bit much there. All right, now who prepared this document? If Mary C. Whitfield was MERS assistant secretary, okay, and she is signing this document over to a bank, okay, who drafted this document? So we scroll down below here, we see document prepared by Mary C. Whitfield, J.P. Morgan Chase Bank, N.A., 780 Kansas Lane. What? When recorded in the J.P. Morgan. So you mean to tell me she works for J.P. Morgan and MERS? She wears playing two positions, and MERS is a beneficiary and a nominee? Man, it's a whole lot of funny stuff going on. Now, the problem with Mary C. Whitfield is she's claiming to be a representative of MERS. But on the document I just showed you, which was the original deed of trust, there is no signature of anybody representing MERS. So if nobody was at the party, how could they eat? Well, if you don't know that they wasn't at the party, then they're going to eat really well. But it's simple documents like this that we just take a look at and we see it don't make sense. It just does not make sense. So this document, we're looking at this deed of trust. There is no meeting of the minds. There's no Mary C. Whitfield nowhere on this document. So Mary C. Whitfield had no right, power, or any entitlement to be signing this document. So this document is technically fraud. This is fraud that was recorded upon the record of this county. And this woman, or whoever this is supposed to, if this is even a real person, is the one who submitted this document as a beneficiary, not trustee. Notice we ain't said nothing about the trustee. Allen is nowhere mentioned on here. If anything, if the contract was signed by Allen, if this deed of trust was signed by Allen, Allen would be the one transferring the deed of trust, not the beneficiary. Why? Because the beneficiary is the child. The children cannot tell the babysitter what to do. Okay? Now, let's check out something else. All right. Now you see it. Yeah, right there. MERS, Procedures Manual. Now let's take a look at something else, shall we? Transfer of beneficial rights to member investors. They have an overview right here. Okay, this gives you a little information. I'm not going to read over there. I'm going to let you read it on your own time. Keep this video short. Let's get straight to the meat and potatoes. We're talking about terms and conditions, and I already have it highlighted for you. Right? Beneficial. Transfer of beneficial rights. Page 63. Terms and conditions. What does it say right here? MERS agrees not to assert any rights. With respect to such mortgage loans or mortgaged properties. Look right here. MERS and the members agree that the MERS system is not a vehicle for creating or transferring beneficial interest in mortgage loans. Transfers of servicing interest reflected in MERS systems are subject to the consent of the beneficial owner of the mortgage loan, and membership in MERS or use of MERS systems shall not modify or supersede any agreement between or among the members having interest in mortgage loans registered on the MERS system. Now, I don't know about y'all, but MERS themselves just said they don't have any rights in these mortgages. So if they understand they don't have no rights, what gave Mary the right to do what she done or what she did? I don't know. we're going to have to figure out, because we sent some letters off to some people to ask some questions. So if you're interested in this type of information and following back up, please go to my website and you can see more details of this certain situation, the steps I've taken to put everybody on notice for this, and you can follow me along with this situation. Peace and prosperity. Take care.